Hi, at the time I'm recording this video, we are in the midst of the coronavirus, and me and my law firm, we seek to get information out there that will be helpful to people in the real estate industry about coronavirus. Now, we provide this information with a little bit of trepidation, because in moments of great crisis, sometimes we do things, sometimes we say things, sometimes we conclude things that look foolish 2 years or 2 months or 2 weeks later. So with that disclaimer in mind, let me proceed in addressing a discrete question that I have been asked. And the question I have been asked is today, and I believe today is March 20th, Friday, March 20th. I have been asked the question, so John, suppose I have existing real estate deals that are under contract. They're set to close at some point in time in the future. Is there something I should be trying to add to the contract to protect my client because of the coronavirus scare? And let me suggest a process for addressing that. First of all, these complications are these issues, these what I will call force majeure kind of issues, are phenomenally complicated. You'll see that in a subsequent video, not this video, but for right now, take my word for it, they're potentially phenomenally complicated. I guess the air quotes were for force majeure, not phenomenally complicated. They're phenomenally complicated. And so in theory, and I realize this is in theory, everybody should consult their own lawyer about what they need. Now, even though it is not practical for everybody to hire a lawyer, even if everybody wanted to hire a lawyer and wanted to pay for the lawyer, the legal profession could not satisfy that demand. Nevertheless, you can still have a trail, an email trail, a paper trail of advising your clients to talk to a lawyer about these things. So definitely do that. Send them the email. Most of them that won't, and then they won't talk to a lawyer. And then here's how I encourage you to think about these situations. For an existing contract, the first question you have to ask yourself is, at the moment in time you're asking that question, should I try and get something into the contract to address coronavirus? Is your clout now, as you're asking that question, somehow greater to protect your client than it would be if the feared problem came up later? Let me give you an example. Suppose you're involved in a transaction right now. It started on day 0. The transaction's supposed to close on day 40. It's scheduled to close on day 40. There is what we call in Colorado a loan termination deadline on day 35. And a loan termination deadline essentially gives the buyer, if there's a loan involved, the almost a whimsical ability to terminate the contract. Well, but at any point in time before the loan termination deadline has passed, the buyer has a lot of clout to terminate the contract because of COVID-19 risks. Because before the loan termination deadline, the buyer definitely has a good faith question about whether the loan will actually be funded. And so in that situation, before the loan termination deadline, the buyer has a lot of clout. Once the loan termination deadline passes, the buyer tremendously loses clout. And so if you're on the buyer's side of the transaction and your buyer seeks to get a clause into the contract that would allow the buyer to terminate due to COVID-19 risks, it is a good time to bring that up before the loan termination deadline. If you're after the loan termination deadline and you're in that 5-day window that I just described, I would suggest you not bring it up. There's 2 reasons not to bring it up. One is that it has this rocking the boat kind of risk. Your client doesn't have any more clout than they would have when the problem actually does come up to try and address it in a sensible manner with the other side. And it could make the other side wonder whether you're acting in good faith, truly concerned about like the inability of the lender to fund or the inability of the title company to close the transaction, which the seller might perceive as legitimate reasons to get out of the contract, versus things that the seller might not think as legitimate reasons, for example, buyer remorse. I would suggest it will be more credible to bring the concerns up as those events actually occur. That is my 2 cents on that question. We are now ending our video. Remember, in addition to being a complicated world, it is also a world that's gotten a little scarier, so be careful out there.